Hi there, I'm Jenna Layton-Jones, the Vice President of Legislation for San Diego SHRM, and today I'm bringing you your quarterly employment law update. Let's start by taking a look at some new California legislation. Governor Jerry Brown has signed a bill requiring California employers to provide paid sick leave to their employees beginning on July 1, 2015. The Healthy Workplaces, Healthy Families Act of 2014 requires employers to provide paid sick leave to employees who work 30 or more days in a calendar year. Paid sick leave will accrue at a minimum rate of 1 hour for every 30 hours worked, and an employee may begin using paid sick leave beginning on the 90th calendar day of employment. Employers may limit an employee's use of paid sick leave to 24 hours or 3 sick days in each calendar year. Employers may set a minimum increment of at least 2 hours for the use of paid sick leave, which can be used for the personal illness or preventative care of the employee or the employee's family member, or to recover from domestic violence, sexual assault, or stalking. An employee will be required to provide his or her employer with reasonable advance notification of the need to use paid sick leave if the need is foreseeable, or as soon as practicable if it is not foreseeable. Accrued paid sick leave will carry over to the following year of employment, but employers are entitled to cap an employee's accrual at 48 hours or 6 days. Employees are not entitled to a payout of accrued but unused paid sick leave upon separation from employment. However, if an employee is rehired within 1 year from the date of separation, any previously accrued but unused leave must be reinstated. An employer will be required to maintain records of its employees' accruals and use of paid sick leave for at least 3 years. The notice provided to an employee at the beginning of employment pursuant to the Wage Theft Prevention Act must include notice of the employee's right to paid sick leave. Moreover, employers must provide each employee with a notice of the amount of paid sick leave or paid time off available to the employee on the employee's itemized wage statement or in a separate writing provided on each pay date. Employers must also display a poster created by the State Labor Commissioner notifying employees of their paid sick leave rights. Employers are prohibited from retaliating against an employee for using paid sick leave, filing a complaint with the Labor Commissioner alleging retaliation, or cooperating in an investigation of an alleged violation by the employer. Employers that already provide paid sick leave or paid time off that satisfies the new law's requirements are not required to provide any additional paid sick leave. The new law exempts in-home support workers, most employees covered by collective bargaining agreements that provide paid sick leave or paid time off, and construction industry employees covered by collective bargaining agreements entered into before January 1, 2015, or that expressly waive the requirements of the new law. Employers should immediately begin making arrangements to comply with the law. Employers with existing paid sick leave or paid time off policies should ensure that their existing plans comply with the law or adjust those policies as necessary. Now let's switch gears and take a look at some of the recent judicial decisions that may affect your business. The California Supreme Court has narrowed the commission salesperson exemption. In Peabody v. Time Warner Cable, Susan Peabody was a commissioned salesperson who sold advertising for Time Warner Cable. Peabody was classified as exempt from overtime under California's commissioned salesperson exemption. Among other things, the exemption requires that an employee's earnings exceed 1.5 times the minimum wage. Time Warner paid Peabody her regular wages on a bi-weekly basis, but only paid her commission wages once per month. Time Warner reasoned that even when Peabody's bi-weekly paychecks resulted in payment less than 1.5 times the minimum wage, her monthly commission payment could be allocated to the earlier pay periods. Peabody sued, arguing that she was not properly paid overtime. The trial court granted summary judgment for Time Warner, holding that Peabody was an exempt commission salesperson. Peabody appealed to the Ninth Circuit Court of Appeals, which certified a question to the California Supreme Court concerning whether an employer could properly allocate commission wages over the pay periods in which they were earned for purposes of satisfying the commission salesperson exemption. The California Supreme Court held that when looking at the exemption, commission wages can only be attributed to the pay period in which they were actually paid. The Supreme Court opined that California overtime exemptions are narrowly construed and must be interpreted in favor of the employee. The court acknowledged that California law permits commission wages to be paid less frequently than regular wages, and that monthly or even less frequent payment of commission wages is permissible, given that commission wages often are not earned until various conditions are satisfied and are not calculable with the same frequency as the regular payroll schedule. Even though commissions are owed only when they have been earned, even if it is on a quarterly, monthly, or other basis, paid commissions cannot be attributed to other pay periods to satisfy the exemption's minimum earnings requirement. An employer cannot attribute wages paid in one pay period to a prior pay period to cure a shortfall. This case makes it more difficult for employers to satisfy the commission salesperson exemption under California law. California employers must now allocate commission wages over the pay periods in which they were earned to ensure that the employee's pay is at least 1.5 times the minimum wage for each pay period. In Rea v. General Atomics, the California Court of Appeal approved deductions from exempt employees' PTO and vacation time for partial day absences of any length. Lori Rea filed a putative class action on behalf of General Atomics exempt employees. General Atomics had a policy allowing deductions from PTO in any amount of time that exempt employees were absent from their jobs for partial days. Rea challenged this policy, arguing that PTO is a type of wage which cannot be forfeited and that the use of PTO for partial day absences violated the salary basis test for exempt employees. The trial court disagreed, granting General Atomics' motion for summary judgment. The Court of Appeal affirmed summary judgment for General Atomics. First, the appellate court found that requiring exempt employees to use PTO for partial day absences is not a forfeiture. Employees are simply using PTO under the employer's terms and conditions. Second, the court held that this type of PTO deduction does not violate the salary basis test. It should be noted that General Atomics made no deductions from exempt employees' salaries, as it is well established that an employer may not deduct monetary pay when an exempt employee is absent from work. However, according to the Rea Court, it is permissible for employers to deduct from an employee's PTO balance for absences of any length. The California Court of Appeal has also ruled that employers must reimburse employees who are required to use their personal cell phones for work. In Cochran v. Schwann's Home Service, a California appellate court held that when employees are required to use their personal cell phones for work-related calls, the employer must reimburse employees for a reasonable percentage of their cell phone bills. This rule applies regardless of whether employees have cell phone plans with unlimited minutes. A putative class action was filed against Schwann's Home Service on behalf of 1,500 customer service managers who were not reimbursed for work-related use of their personal cell phones. The trial court denied class certification, reasoning that some employees' cell phone bills might be paid by a relative, friend, or other third person, and that employees may or may not have purchased different cell phone plans because of work-related calls. For these reasons, the trial court determined that the class lacked commonality and class treatment was improper because the analysis required an individualized inquiry of each employee's cell phone plan and payments. The appellate court reversed, holding that under Labor Code Section 2802, an employer must reimburse employees for all necessary expenditures incurred in direct consequence of their discharge of their duties. Under Section 2802, an employer must always reimburse an employee for the reasonable expense of the mandatory use of a personal cell phone. It does not matter whether the employee's phone bill is paid by a third person, nor does it matter that the employee never incurred additional charges for work use or never changed plans to accommodate work use. To bring a claim under Section 2802, an employee need only show that he or she was required to use a personal cell phone to make work-related calls and was not reimbursed. In light of this interpretation of Section 2802, the appellate court ordered the trial court to reconsider the motion for class certification. Unless this case is reviewed by the California Supreme Court, this decision may fuel a new wave of litigation under Section 2802. Any employer that requires employees to use their their own devices, including cell phones, personal laptops, and tablets for work use, should immediately review its policy on expense reimbursement. The cases I just mentioned are just a sampling of recent judicial decisions that affect California's employers. For more information on these and other hot legal topics, check out San Diego SHRM's newsletter, The Resource, at www.sdshrm.org. Additionally, I invite all of you to join San Diego SHRM's Legislation Committee, where you'll have an opportunity to impact the lawmaking process and the legislative decisions that affect you and your business. For more information about this exciting opportunity, please email me at jleyton@pettitcone.com. That's pettitkohn.com. That's all for this quarter's legal update. Thanks for tuning in.